Greetings everyone, it is Zakes here, and today we are back with our weekly videos. We would like to change our pace. We usually talk about things the government should not be doing. This week we are talking about the things the government should do. Ideally, how the government should look like, right? The legal system of the South African state and how much it should respect property rights. A lot. It should respect them a lot, but how really should it do this? But that would be the video today. Our video is premised on, one of the papers from our Liberty First series that we released last year in our, eagle selves, trying to get the GNU on the right track to make South Africans prosperous. But one of the papers is titled, the legal system and property rights. And in the paper written by Martin van Staden, he makes a case, right, for how the South African Constitution and the South African government ought to, take heed of things like federalization, the rule of law, respect for private property, and general respect for civil liberties. And today we'll be talking about that, starting at federalization. I know a lot of you, when I mentioned it, you thought, man, these guys are talking about something that cannot exist in South Africa. But, if you did not know, our Constitution is of a federal nature, right? We have in Parliament two houses, right? The National Assembly and the National Council of Provinces. That should tell you that provincial power ought to be a real thing. It's just that in most cases, the national government is governed by the same party that governs a large majority of provinces in South Africa. And as such, you don't get to see what I think the constitutional drafters wanted to see, the variety in policy and general party affiliation that would reflect the variety of South Africans themselves, right? But South Africa is a federal nature, a federal state, for lack of a better term, right? Not as strong a federal state as the United States of America, as an example, but still a federal state nonetheless, right? Provinces are allowed to have things like constitutions, which the Western Cape is the only province that thankfully has one. But, provinces ought to be independent, and as part of the recommendation made in the Liberty First paper, we argue that more powers should be given to the provinces. Currently, the powers that are given to provinces are defined by the South African Constitution, right, in its various schedules, which set out the competencies of the national and provincial governments. And we argue as part of the recommendations that the shared competencies between national and provincial governments ought to be really devolved more or less, in most cases than not, to the provincial governments, right? Because the things that affect people should be as close as possible to those people themselves, right? Currently, the problem in South Africa with the push for centralization that we have seen over, I would like to say, ever since the National Party came into power, but, in the post-democratic era, really, the push for centralization that we have seen sees someone who lives in the Northern Cape, someone who lives in the Eastern Cape, having their political and economic destiny determined by someone who lives in Pretoria, someone who lives in Cape Town, right? And that should not be the case, because in most cases they're not. Someone who spends most of their time in Gauteng, in Pretoria, or spends most of their time in the Western Cape, in Cape Town, does not understand the intricacies of, the things that affect someone in the Northern Cape, that affect someone, in the Eastern Cape, in KwaZulu-Natal, in Limpopo, in the Northwest. And as such, when the power to determine the political and economic lives of the people in those provinces that are far removed from the centers of power is shifted away from them, in most cases they're not, that results in an injustice, right? Just by its nature, to me, it seems like an injustice. It is an injustice because everyone has the right to self-determine. And I argue that the right to self-determine is made much more harder when the centers of power are far removed from you and your influence. And federalization at its core, really, it is about bringing the centers of power as close as possible to the people who are affected by them, so that the people themselves can exert influence on said centers of power, bringing the idea of the state much more closer to reality, the idea that the state really is a representative of, the whims, for lack of a better term, of the citizen, under which its territory is covered in. But federalization is good, right? As libertarians, we always argue for this, and the South African state and through the South African Constitution gives rise, right, to federalization, to a federal nature, or the federal nature of a particular government. Another recommendation in the paper is an adoption of legislation that would give rise to this federal nature of the South African government, right? I am personally interested in this because I've written a lot about, how different the crime statistics in the Western Cape, for instance, would look if the Western Cape government was given the power to determine its policing destiny, for lack of a better term, right? They have proven, the provincial government of the Western Cape, in every other area of people activity, that they are quite well versed and when competent in general to deal with whatever challenges that governance throws at them. And as such, I think that policing is something that should be devolved to provinces, specifically to a provincial government that has proven to do well as they have. And the fact that they have such high crime numbers actually is much more pressing, right? The people of the Western Cape should be able to determine their policing destiny. The police in the Western Cape should be held accountable by the people in the Western Cape instead of being held accountable by a national police commissioner who in most cases that not only comes to the Western Cape once, twice a year, right? So really things like that are things that ought to be given, expression through legislation, right? That would give rise to these constitutional principles, and that would further enhance the protection of, the rights of South Africans. Because, as I said, the reason that that devolution is good is because South Africans in their differences all over the country will then get to exert influence over centers of power in things like policing or education even, or healthcare in a much more bigger sense than currently is the case, right? But the federal character of the Constitution should be given expression, and that is one recommendation that we have in how we would like the South African government to look like. Because, as we've mentioned, federalization is good, and overall the more decentralized things are, the better they are, because when one thing fails, you still have the option of other things. And I think that is something we should really be striving for, as a country, irrespective of all the fundamental rights that federalization gives better protection to. And then another point would be in the rule of law, right? So the rule of law is, important for any prosperous functioning of a society, right? You need predictability in law. You need an ability for the law to apply to all equally. You need the law to be rational, to be reasonable, for a society to be prosperous. And one of the recommendations that is offered in the paper is the abandoning of any notion of the confiscation of property without any form of compensation by the South African state, right? And this is something that is pretty important, because the idea that the state needs to confiscate property without any form of compensation is usually equated with the idea of justice for people whose property was confiscated by the previous South African state that was run by a different government or under a different dispensation, right? And that is not the case. It is not an either or. You can have justice whilst not confiscating property from people without any form of payment from them. The two can exist at the same time, and that is what to argue for, right? The property rights are the basis of every economic transactions. They need to be protected, especially by a jurisdiction which happens to adjudicate any conflicts arise about said property rights, the right that may arise. But really, any jurisdiction that has a monopoly on violence, like a state, ought to respect these, because the people within said jurisdiction cannot have any viable economic lives without a respect of this. And we see this in a lot of African countries, but for us most telling in Zimbabwe, right? Zimbabwe tried doing this. They tried confiscating property, and even after now in the modern day, when they are willing to pay the farmers whose property they confiscated, still their economy finds it hard to recover, because once the idea is put out in the world that a certain government can take your property, no investor, if I had capital, would not want to put it in Zimbabwe, because the government could take said capital, right? So that is very hard to shake away, as we are seeing in other economies once it has happened, because the basis of any economic transaction is a respect of property rights, right? Someone to invest in a particular jurisdiction, even domestically amongst individuals, for me to be able to give you capital as your friend friend or as your family member, we need to have an understanding that the capital is mine, and the capital, I am entitled to it under whatever terms or conditions that we agree to. Once you take said capital that I gave to you without giving me anything in return, then it makes it harder for me to ever give you capital in the future, because you have shown me that you are capable of doing something like that. So really at a practical level, it comes down to that. And again, to reiterate that this does not mean that justice ought not to be done concerning the land question, for lack of a better term. Right? Given the South African history, we know that there are rights that have their basis in injurious actions, for lack of a better term, right? Rights that really ought not to be respected, and that does not mean that the state has to confiscate property without compensation, but that merely just means that the people whose rights were disregarded on the basis of force and violence in our history can just be restituted, can have their property rights taken back to them in whatever form that they may deem fit, right? And the best way to do this is through adjudication, right? Just through the courts of law. That would be the best, most peaceful way to do this, the most orderly way to do this, because again, right, the restitution means that certain people will get to have certain property which they are entitled to. Not everyone is necessarily entitled to everything, and as such, the determination of these nuances is something that is best done through an adjudicative process, right, through a court process. And one of the recommendations in the rule of law is the capacitation of the land court, right? The land court has to be capacitated. Given the rhetoric that the South African politicians and South African leaders have about the land question, about the need for land justice, the fact that the land court is not as adequately resourced as it ought to be, in my estimation, betrays really the words that they say. It shows where their priorities are, our leaders, because they can address the land question in a manner that will yield the most positive results for the broader South African society if they would capacitate the institutions that are already there established to try and facilitate justice around this very, very important question, right? But because the leaders themselves, I don't think they actually believe the things that they say, given their actions, right? Maybe they do, but given their actions and not capacitating, institutions like the land court, it shows that they do not believe, at least in the pursuit of justice through that means. And one of the recommendations we have is that the land court has to be sufficiently resourced. It needs to have either monetary and human resources to be able to deal with the plethora of claims and the plethora of cases that it has before it, so that we can start making progress on this question that has plagued this general South African context, one would say, for centuries. But it is not something that is unsolvable, and it is best done through the confines of respect for human rights and due process. But maybe that is just me being biased, since I am legally trained. And then another recommendation, a pretty important one, at least according to me, is a return of all our minerals to South African citizens. I'm not sure whether you're aware of this, but through the Mineral Resources Act, if you have minerals underneath your property, maybe on a farm, maybe on communal land somewhere, or maybe on your family's home, if you discover that you are sitting on, a pile of gold, you do not own that pile of gold. The South African government owns that pile of gold. And the South African government can decide to give the rights to mine that pile of gold to someone else who is not you. And using expropriation legislation, they can then take your property without payment, should they be allowed to do that, to give rights to someone to mine that pile of gold underneath what used to be your property, right? So we need a repeal of legislative provisions like that, right? Because every community person should be entitled to what is beneath and above their property, because it is their property. We would avoid situations like what we saw with the community of Olobeni, right, a couple of years ago, whereby the Mineral and Energy Department wanted to give mining rights to a company which the community had really vociferously rejected, right? It rejected having mining operations being done in its community. The community members did, but because they did not have rights to the mineral resources, legally the Minister of Minerals an energy in, I think, what was former Minister Kwede Mantashe. He probably still is the Minister of Minerals and Energy, right? He could then give the mining rights to anyone who he deems fit, and that person would have a sound legal basis to go and mine in that particular community or area, even though the people who live around said area, right, would have been opposed to it. And that alone really, and the recommendations that we have cut across, everything was spoken about, because if Xolobeni was in a province that recognized, or was in a state whereby there were federal powers, and the person who was taking that decision would be much more closer to them, and in most cases than not, it would have been harder for that person to take the decision that they did, right? If the law did not exist, which we say should be repealed, in the fact that all mineral resources are owned by the state, then the problem in itself would not exist, right? So really, all the connections, all the solutions are interconnected. But in this instance, the recommendation to me is pretty important, because I believe that South Africans, no state should ever be entitled to what is on people's property, as a general rule, right? But that is just, the libertarian in me speaking. Of certain legislation and the reform of the land court, which I think is an important thing in dealing with land justice, right? Another recommendation is land justice should be pursued, right? Land restitution, and a changing of not equating redistribution, which is contingent on political whims of certain individuals and parties and institutions, right? And then replace the entire rhetoric around the land question with restitution. We should be focused on restitution. We should be focused on justice, on putting people in positions where they would have been had an injury not occurred, instead of trying to socially engineer the most, I guess, demographically representative split of land ownership or whatever it is the cause behind redistribution. Really, we would never know, but I find redistribution to really betray a lot of the things that restitution is premised on. But really, in general, the recommendation is that we should move towards justice, and this is something that I personally am a fan of. Let us move towards justice instead of redistribution in general. And then there is civil liberties, right? So one of the last recommendations is in the protection of civil liberties, and I'm sure this is something that most of us agree on, and chief among them really is a focus on the non-inhibition of speech, right? In South Africa, we have a lot of things that tend to inhibit our freedom of speech, things like the Hate Speech Act. One of the recommendations we have is let us just repeal the entire thing. It should not exist. The ability to express oneself is very important in a society, especially one like South Africa, because it allows us to express different viewpoints, and then those viewpoints will then inform whatever decision we take going forward, which will have an appreciation of, the variety that is present in our society. And I think when we inhibit the ability of people to express themselves, even though it may feel good that certain people are not saying things that we disagree with, it does not eliminate those people, nor does it eliminate those thoughts. If you are a consequence-based type of person, it just delays the problem, right? It means that someone will think something that you disagree with and you won't know at a practical level, and I would just prefer to know. It is always nice to operate on a level of truth, and I think speech enables us to operate at that level, and hate speech and legislation like the Hate Speech Act undermines our ability to operate at that level, right? We have the Constitution, which already inhibits threats of violence and things like that, and even though I may not disagree fully too with the constitutional provisions on free speech, but I think it is sufficient enough. We do not need further legislation to further inhibit, the ability of people to express themselves. And another recommendation is in reforming crimen injuria to neuter it as a measure to address harmful expression, right? So like crimen injuria has been used as a tool, as a stick to beat people who say things that other people deem hurtful, that other people do not deem to be appropriate, right? But speech by its nature cannot violate anyone's rights, because it does not inhibit the actions of anyone, nor does it harm their entitlements to their property rights, meaning that it becomes a subjective exercise about what is harmful, what is hurtful, and what isn't. And crimen injuria, which is recognized in our common law, which there are plenty of case law about it, is then used as a manner manner to inhibit people's speech in a very, what I would argue, arbitrary and subjective manner for the reasons that I have stated. And as such, we argue that it should be reformed, it should be changed, it should not be the way that it is currently. I ideally would not like it to even be recognized as an injury in our law, but the recommendation is saying that we should at least look for reforming it. And then repealing the Hate Speech Act, and in general, right, the recommendations and civil liberties seek to argue for an enhancement of the right to free expression, and most importantly, for the applying of rules that do inhibit free expression should they exist, and which I disagree with, but the application of said rules equally across the board, right? So we should not have an instance whereby hate speech directed at certain people is punished by the law, and hate speech directed at other people is not punished by the law, because that creates an inconsistency in the law itself, in the application thereof, which really just makes the law, for lack of a better term, an ass, as would be said, because no one would really take it seriously, because it would be clearly in favor of one person or one group against the other, which it should never be the case, right? And as such, if the inhibitions would exist, they should be applied equally across the board, and that is one of the recommendations. I, of course, at a personal level, don't want any inhibitions to exist, because I think that really just solves the problem altogether. But those are the recommendations. Those really are the general themes under which the paper gives recommendations for the South African government to follow for all of us to be prosperous. Now, please do tell me what you think. Do you agree with the recommendations from the paper? Do you disagree? Do you, maybe think that, hey, we don't need the rule of law as much, right? And, we should pursue redistribution instead of restitution as, an angle of addressing past injustices. Please do tell us what you think. Give the video a like, share it with whomever it is, subscribe if you're unsubscribed, and as always, remember, stay free.